Number 101 on the calendar, the people of the state of New York versus Vilma Bautista.
Good afternoon, Your Honors. I'd like to reserve 2 minutes, if I may.
Of course.
My name is Nathan Dershowitz, and I represent Vilma Bautista. I understand the court is familiar with the facts, but I would just like to highlight a number of facts in terms of specific dates, because I think they're critical on the question of intent. On April 4, that's when Bautista and Abaya went to see James Sherwood. They told him that Bautista sold the painting on behalf of Imelda Marcos. That was inconsistent with the people's theory throughout this trial and was consistent with an extensive amount of evidence throughout the trial. What then happens is that ties in, of course, to the tax counts as well. And what he was told at that point, what Sherwood told them at that point is, you can't, Vilma, you can't pay her taxes. She has to pay your taxes, but more importantly, he also said, I'm not sure she has any taxes. And if Marcos has no taxes, that solves the whole problem. So at that point in time, there were a lot of complex questions, and the tax return gets filed on April 16th by somebody by the name of Sebastian. He was supposed to have been told by Abaya. Abaya, Sherwood testifies, I told Abaya to tell him to put it off, extend it. So the actus reus of filing the return was on the 16th of April. And the question then becomes, did she have the mens rea at that point in time? That was the core question on April 16th. The defense was a very simple one. She wasn't sure how much she had to pay. She wasn't sure if she had to pay. She was waiting for Sherwood to get back to her so she can make a determination. Sherwood's testimony is extremely helpful to the defense. And so you then have Sherwood asked on direct and on redirect, specifically, did you ever have a discussion with the defendant about her tax liability? He says, no. Matter of fact, I never spoke to her after.
But he also had an arrangement, did they not?
I'm sorry?
They had an arrangement, did they not, that Mr. Abaya would serve as the conduit for information to flow to Mrs. Bautista?
Your Honor, by the time we're talking about, there were no questions that related to Bautista. The only issues that he was retained to address, only issues that Sherwood was retained to address had to do with Marcos, and they took that position at trial and have taken the position today.
Was the tax lawyer operating on full information on all the facts?
Yes. And the answer is flat out yes. Because despite the government's arguments to the contrary, the answer is yes, because the question at that point in time was, if the painting belonged to Mrs. Marcos, and you had the defendant acting on behalf of Mrs. Marcos.
But wouldn't it have been relevant to that question to know where the proceeds went?
Again, there was a technical legal question that was raised, but we're getting off, with all due respect, there's a tangent. What I'm talking about is on April 16th, did she have reason to be confused? Did she have reason not to be sure that she had to pay taxes and how much taxes? And remember,
I thought your argument was that she was operating under the advice of counsel. And am I wrong about that?
I'm not.
So what you're saying is that she never sought anyone's advice about what she had to do if, in fact, that money was used in the way that at least the prosecution says it was used?
She was told to get her tax return put off. And in answer to the Chief Judge's question, Abaya was supposed to deliver that information. He didn't. So there's no reason to assume that Abaya was acting as a conduit, because the only testimony that we have as to whether he acted as a conduit is that he didn't act as a conduit. That's first. Second, as to whether or not Sherwood even told that information, it wasn't passed on, Your Honor. With respect to the question as to whether
She enters that agreement with the three of them. Is she not charged with that knowledge?
No.
No?
Not on the tax return. We're not talking about a conspiracy
Well,
charge.
as
We're
it
talking about
goes
a
to her
tax-
intent on the criminal tax fraud.
But again, not everything that's conveyed has to be relevant. It has to have been logically extended. If you're talking about Marcos's tax liability, why should that information, why should something relating to Bautista's tax liability, which is not the question that Sherwood was hired to discuss at all, why should we assume that it was passed on? Let me just add.
But isn't the question whether or not an inference can be drawn, and that's where the people are making their argument.
That's correct.
And that's what they presented to the jury, an appropriate inference based on the evidence admitted?
And let me be clear on that. As far as I am concerned, you can never misstate the factual testimony of a witness. You cannot say, this witness said A, B, C, and D. He told her to pay her taxes, told her to pay her
Didn't the
taxes.
court take corrective action on that repeatedly?
But not all the time.
Well,
Fran
but
Hoffinger
more than
objected
once,
each time.
More than once. And is there any indication in the record that the jury ever asked to hear any of this testimony?
No, there's nothing in the record. But, Your Honor, as to the third effort, the first effort was defense witness confirms she was told you must report. That was inaccurate. He then rephrased it. The rephrasing was he told them. There was an objection to that. He then withdrew that. The third one was the limited advice he gave Bautista, he fails to follow, simple as that. That's objected to. The court allows that testimony in. He then says.
Well, it's not testimony, it's only a summation.
I'm sorry?
When he comes back to it in summation, it's a summation point, right?
This is in summation.
Yeah,
And in
he's-
summation, he then goes on, I'm reading the summations. And then he goes off to say it was
That was my
communicated multiple times, you must file taxes on your gain. Each one of those is incorrect. If you want to have an inference inconsistent with the witness's testimony, the best example would be if you have a witness who had a discussion with a defendant, and the defendant denies culpability, but says certain things at that time which may be inculpatory. I have no problem saying the witness said A, but you can infer B, C, and D from what was said. But you can't say the witness said he can. The witness testified that he
Can you infer
confessed.
B, C, and D if the witness walked out of the room and a conversation kept going on because they've entered this arrangement where there's a conduit that stays in the room?
The arrangement, again, you have to differentiate between Marcos, which is the only issue that was pending, and they concede that Marcos is the only issue that was pending, not Bautista. Can I take 1 minute
Counsel,
on
do
Brady?
you care to address the Brady issue?
Yeah, that's what I'd like to
Please,
address.
take a minute.
Okay, this court has established two different standards with respect to Brady. And there's a significant difference between the two. And one is the reasonable possibility, which applies in our situation where there was a specific request for a document. And the other is the federal standard, which is a much higher standard. And I think it's Judge Kaye in one of her decisions who highlighted that, you're really adding a burden onto a defendant when you presume the accuracy of the factual materials when you look at it retrospectively, as compared to what you want to do is put the obligation on the prosecutor to disclose the information openly and accurately. The Supreme Court decided a case about 2 months ago, Turner versus the United States. And in Turner, it reaffirmed exactly what the standard is in Brady. But what is interesting is the court went out of its way, both in the majority and in the dissent, to say that the reason they're doing that is largely because, and let me try to get the quote, because there was an open policy on the part of the prosecutors where they will provide information the defendant might wish to use. Okay, they said it was a generous policy of disclosure. Therefore, we don't have to change the standard. In New York, there is no, certainly this case shows, that there is no generous policy of disclosure, and certainly they don't disclose information that the defendant might use or might wish to use. So if you want to enforce the principles that you've articulated, then you have to have a lower standard, and you have to review it in terms of whether or not there is a reasonable possibility of a result. Let me give you one specific factual example of why it's clearly obvious that this could have had an impact. You have Abaya saying he knows Vilma's signature. I mean, not Marcos's signature. The prosecutor had argued throughout the case, on the basis of this authorization that had been given, that we don't even know whose signature that is. We don't know
How does that
the-
undermine the jury's confidence with respect to the criminal tax fraud,
Yes.
that he could recognize her signature?
Because what they argued was the whole thing is a scam. It's a lot different to argue the whole thing is a scam.
Well, I'm focusing on the criminal tax fraud and the offering the false instrument.
If I can answer that indirectly, I'll get back to what I was going to say. This case is in a strange posture because all of the errors that occurred at the trial, we argue this should be a spillover. When there was a reversal on all of the other charges, 95% of the case, Your Honors don't have before you the issue of the spillover effect.
Correct.
And so it makes it artificial in terms of what we're doing. And I've asked that the court read over, for example, the closing arguments where you have 36 objections to Fran Hoffinger's closing argument and being pulled up to the bench and all these conversations. I suggest the whole trial was not fair. But going back to and it's hard for you to evaluate that. I understand that. But the point I was making with respect to, there's a big difference between a notary not having the signator present when they sign it. But the argument that was being made here was that this whole thing was a fraud, and she had no authorization to sell the painting. We don't even know if it was her signature. And again, the defense here was simple. On April 16th, as to the tax count, on April 16th, on that day, did she have the intent to defraud, or was she waiting for a determination to be made as to what her tax liability would be so that she can then file an accurate return? And Abaya never conveyed that information over. What Sherwood said to Abaya never conveyed over to the person who filed the return. So it ties in.
Thank you, Mr. Dershowitz. Counsel?
Good afternoon. Thank you, Your Honor, and may it please the Court. I'm Garrett Lynch on behalf of the District Attorney for New York County. Now, while cases in...
If we assume that the prosecutor in summation can ask the jury to make certain inferences from the evidence, would you agree that here, that wasn't made clear that that was what the prosecutor was asking the jury to do?
The prosecutor, I think, was drawing a very fair and logical inference. They're allowed to draw that inference and make that argument. I don't think there's
I guess my question is, should the prosecutor have said, you know, here are the facts, here's what the testimony was, but because of this whole arrangement, you can infer that she knew that this information was presented to her?
Sure, but I don't think there's a requirement to break it down into its constituent analytical parts. I mean, that obviously may be a more fulsome explanation of what's going on in the prosecutor's mind, but at the time, he's making the inference that they can draw. And the inference...
When defense counsel objected to all of this, should the court have made it clear to the jury that that's what was going on?
Well, I'm not sure. I mean, I think the court acted appropriately, saying at one point the court makes explicit, ladies and gentlemen, obviously there's a disagreement between the prosecution and the defense about what Mr. Sherwood said and the inference to be drawn. It's up to you and your recollection, and please consult the record. And actually, in fact, the prosecutor then reiterated that.
Did they get
and
the
actually
record
told the
during
jury, please
deliberation?
consult the record.
Did they ask for this record during deliberation?
They did not. They did not. But again, I think it's firmly rooted in the record and the evidence that the inference was fair.
Charge, I'm sorry to interrupt.
That's okay.
Did the court give a charge as part of its final charge that in order to draw an inference, you first have to find the underlying fact as established beyond the reasonable doubt?
I don't think there was a fair inference charge given to the jury explicitly, but of course the charge was given to them explicitly that it is your recollection of the facts that controls, and it is the record, and you can access the record. So again, I think that the inference that was drawn was logical. It was, frankly, it was the only inference that could be drawn. And I do want to correct one thing that counsel did say, which is the one statement that the prosecutor made that wasn't corrected by the court, or whether an instruction did not follow from, was that Sherwood made it expressly clear on multiple occasions that she had to pay her taxes. That's unobjectionable. That's not saying that he told her. It's saying that's what he said. And I don't think that's an objectionable statement. And because, again, the express arrangement when all three parties sat down was all communications with Ms. Bautista will flow through Mr. Abaya. And that was consistent with other testimony throughout the trial of people who were involved in this transaction. The attorneys for the seller of the painting that Ms. Bautista sold, that was the express arrangement with them as well. Frank Lord testifies that all communications went through Abaya.
Excuse me. Now would be a good time maybe to turn you, if that was their express arrangement, then let's turn to the Brady issue for a second, all right? The appellate division analysis basically says that it presumes that Abaya would have taken the fifth. You agree that's what it says?
Well, I'd clarify, Your Honor. The appellate division said two things. They said, first, this is not Brady material, period. Moreover, it is highly unlikely that it's likely that he would have invoked.
Let's stick with the presumption then.
So I think they were finding two of the three Brady prongs deficient. That one, it was not exculpatory. Two, it wasn't material.
Excuse me. The court did an in-camera review, so I suppose I think they might have a basis to say that. But this presumption of the invocation of the fifth, do you agree with that analysis?
Your Honor, I do, because of this court's opinion in Ennis, E-N-N-I-S, which makes it abundantly clear that the Fifth Amendment rights of a witness alone can be the basis for a finding that that witness's statements are not material. Because, as the court stated in Ennis, there's no way the defense ever could have gotten those statements before the jury, because they were inadmissible. And moreover, the witness had a Fifth Amendment right that very likely would have been invoked. And so in Ennis, the court found that alone.
So do we speculate in the
for
context of that Brady analysis? Do we speculate as to?
Well, it's interesting. In Ennis, they didn't even speculate. They said full stop. The fact that this witness had a Fifth Amendment privilege alone is enough for his statements to not be deemed material. But here, I think
I don't know, that's not my experience. My experience is usually you're given some proffer outside of the presence of the jury to make some sort of a determination. And beyond that, the Fifth Amendment right, it's a precious right, but what's also a precious right is the right to ask the question and have someone take the Fifth Amendment. And that's an entirely different situation, because that as you say, this trial, as you both said, this trial involves a number of moving parts, and some of which are not in front of us. But the effect of taking the Fifth Amendment is, on a witness's credibility, is substantially undermined when you can't even ask them the question.
Well, Your Honor, we're in prong 3 of the Brady violation analysis.
Yeah.
Again, we would submit.
And you say it's not even be prong 1.
It's done on prong 1. Two courts had the notes in front of them and deemed the notes not to be exculpatory Brady material. Prong 2, the information wasn't suppressed.
To be honest, Court of Appeals, I'm not always concerned, though obviously we're concerned about the litigants in front of us, but also the language itself and an effect it has on other cases. And the language proposed here could have serious effect in other areas. So it's not as simple as that, is what I'm saying to you.
Well, Your Honor, again, I think that the appellate, let's not confuse the appellate division's language. Again, it said this was not Brady material, full stop, moreover. So it was finding a failing on 2 prongs, not a single prong. So I don't think necessarily this is the right case to invite this analysis of whether, or revisiting the Ennis decision of whether or not a witness's Fifth Amendment privilege can be the basis for a materiality decision. I don't think this is really the appropriate case for that. Also because, again, I think they cannot establish any of the 3 prongs by the Fuentes prongs or Strickler prongs. And so, again, I don't think this is the appropriate case for that, because materiality has to require some level of speculation, right, of what would the impact be if this information had been disclosed? What would the impact have been? And so I don't think it's inappropriate to, in the basket of things in determining whether or not prejudice flowed from this material not being given to the defense, there is an element of speculation, which includes, for instance, in this case specifically, none of Abaya's statements were admissible. It was all hearsay. It was all speculation, opinion. None of this would ever get in front of a jury anyway. Moreover, he was an unindicted co-conspirator represented by counsel who had a Fifth Amendment right. So that's another issue that you put into the basket of what is the possible impact of this evidence on a jury potentially. And again, in the larger context, the potential impact on the tax
Was there
crimes
anything in
revealed.
those notes that was based on Mr. Abaya's personal knowledge, besides perhaps the statement that he recognized Mrs. Marcos's signature?
I'm not even sure that was based on his personal knowledge. That wasn't clear, Your Honor, from the notes. So I would submit that there was very little, if anything, in there that was based on personal knowledge. There was a lot of personal speculation and opinion, and there was a lot of hearsay of what Ms. Bautista had told him herself. So this couldn't even have led to any admissible evidence. But again, in the larger context, getting back to the remaining tax counts, because there's a lot of fascinating facts in this case about Marcos and so forth, the fundamental issue here is this is a defendant who sold a painting. She received $32 million for that sale, kept 100% of the proceeds. She orchestrated the entire sale. She ensured that it was entirely secretive. And then when it came time to pay her taxes, she approached her tax preparer, Romeo Sebastian, did not tell him she sold this painting, did not tell him she had received $28 million, did not tell him she had spent $12 million of the $28 million on herself and her family and her friends, did not give him the essential records that would have shown him that. She gave him some records of some bank accounts, but not the records of this bank account. She affirmatively withheld that from her tax preparer. She reported $10,000 in income from all sources that year and paid the state of New York $78 in tax. This Sherwood issue, we maintain, is a red herring. They approached him as a ruse, this whole trying to cover up what they had done. If this was a sale on behalf of Marcos, they created this very Rube Goldberg analysis for him to try to figure out this factual scenario. But her scenario was really, really simple. She received $28 million, spent 12, kept the rest, paid $78 in tax.
Thank you, Mr. Lynch.
You're welcome.
Mr. Dershowitz, what about your adversary's suggestion to us that Mrs. Bautista sat with a tax preparer and failed to apprise him of the fact that she had deposited the money in her account? She bought an apartment, gave her cousins or her brothers money.
Again, the defense was two answers to that. I think what I mentioned before about Judge Kaye is really applicable here. They're looking at it now, retroactively, putting all of the burdens on us. If you look at the other way, take a look at what the defense was when it was looking for some of that information. The defense was a very simple one. She acquired the funds. Sherwood says getting money doesn't require tax payments. You don't pay on what you receive. You pay on what you earn. That was what Sherwood testified to. That's what he said half a dozen times during his testimony. So the fact that she received it, if she got a gift, Imelda would have to pay the gift tax. She wouldn't have to pay a gift tax. She doesn't have to pay on whatever she received. If she got a big gift for everything that occurred, she wouldn't have to pay taxes. But again, we're talking about intent. I need to go over just 4 very quick items, if I may. First, hearsay. If you look at the vast majority of Brady cases, they deal with notes by prosecutors and notes by investigators. Those are all hearsay. So you have to disclose. Of course, they're confused. The trial court was confused. They are presently confused. And we cite at least 1 or 2 cases where it's clear that Brady is much broader than admissible evidence. It's evidence that could lead to other evidence.
What's in those notes, and if what's in those notes is
That's right.
not based on personal knowledge,
Well,
that's
we
the
don't
whole-
know that. They don't know that. We don't know that. That's the whole point. You want to investigate it. You want to check it. That's the whole point of giving the Brady material, so that you could then
When
take
he
the
was
next
questioned
step.
and he was asked for his source or basis of knowledge, he said, well, I assumed that. In several places, though, and I looked through the
Few.
notes, I assumed this, I assumed that.
Right. And then the question is, why do you assume it? What knowledge did you have? You follow it up. I mean, Your Honor, clearly, just as a broad matter, the idea that only hearsay is Brady is simply wrong, and this court should come down with a clear decision that says you can't justify not providing evidence because you say it's hearsay. That's just flat out wrong. Let me deal with the inferences for 2 seconds, and that is one, there's a big difference between a false statement and, contrary to what the prosecutor said, the two admitted statements, no objections, they came in. The limited advice he gave, Bautista, it says he, it should be she failed to follow, simple as that, objection overruled. Okay? So you're saying on intent, I can't imagine anything more harmful on intent than saying you went to your lawyer told you what to do, and you didn't do it. That's clear on intent, and there's no basis for it. The second, later on, again, I submit to you what I am saying, that it was communicated multiple times. You must file taxes on your gain. It was not communicated multiple times that you have to pay your taxes. That's just a false statement, and it's a false statement on the core, the only issue that was litigated. And you have a right to litigate it, and to just simply say, as they say, oh, there was a big scam here, therefore she obviously was guilty on this, just shows the carryover effect, the spillover effect from everything that was done in this case. If they had tried it separately, just as a tax case, I wonder whether the result would have been anything like that. I just want one more point, and that is with respect to the Fifth Amendment. Remember, Abaya wasn't indicted. We don't know why he wasn't indicted. Who said that frequently a co-defendant does testify in a case? There's no logical reason to assume, as a practitioner for over 50 years, that the co-defendant is always going to come and tell me everything that he knows. That doesn't happen in the real world. So, Abaya may well have, I've seen 100 cases where a co-conspirator testifies in a case. Maybe he gets immunity. They could have given immunity if they wanted. I don't know if they would have given immunity or they wouldn't have given immunity. If he is exonerated, they didn't want to indict him. They thought they named him as a co-conspirator, didn't indict him. Maybe they would have given him immunity. That would have solved the problem.
Thank you, counsel.